स्टार्ट.
नमस्ते आस्वाद सर.
नमस्कार साहेब. नमस्कार. कसे आहात?
मी छान. आपण कसे आहात?
छान आहे साहेब मी.
A very good morning to one and all. As we all know, we have gathered here for the session on protection of children from Sexual Offences Act, that is the POCSO Act. But before we, so now I would request that we would start this session. The Government Law College Mumbai has a heritage spanning over a century and a half and has dominated the legal landscape of India since its inception in the 1855. This esteemed institution enjoys the distinction of being Asia's oldest law college and has given generations of distinguished legal luminaries like Justice M.C. Chagla, former President of India, Srimati Pratibha Patil, are the names of a few amongst the many. The college has consistently maintained high standards of education by emphasizing on the crucial balance between academics, co-curricular and extra-co-curricular activities. The NSS unit of Government Law College Mumbai, under the guidance of our beloved program officer, Kritika Temburnikar ma'am, is relentlessly working on the lines of the motto, "Not me, but you." Government Law College NSS unit has been actively organizing awareness webinars and activities like voter registration awareness, fourth Poshan Maha activities, awareness about constitution, judicial backlog, preventive detention laws, reading motivation, etc. are a few of the numerous activities the NSS unit has organized. As we move towards the introduction of our speaker for today, I'd like to introduce Advocate Amit Mahadeshwar sir to you all. After completing graduation in political science from Shivaji University, Kolhapur, sir decided to pursue career in law. Therefore, got admission for LLB in the year 2000 in Shahaji Law College, Kolhapur, affiliated to Shivaji University, Kolhapur. He completed the LLB in higher secondary class in year 2005. During the academic year 2002 to 2005, he worked as an assistant to eminent advocate Shri Pravin H. Deshpande, Kolhapur. He gained vast experience in the civil, criminal, and banking practice through Advocate Deshpande sir during academic years. After achieving LLB SPL in 2005, he enrolled as an advocate with Bar Council of Maharashtra and Goa in the year 2005 and started legal practice. Since then, he had practiced mainly in criminal, consumer, industrial, labor side. He has successfully conducted various criminal trials, consumer cases, and DRT matters till date. In August 2009, sir was selected as a civil judge Junior Division through the competitive examination conducted by Maharashtra Public Service Commission and was appointed as Civil Judge, Junior, DN and Judicial Magistrate First Class at Ahmedpur District, Latur. Sir served as a Civil Judge, Junior, DN and Judicial Magistrate FC till February 2011. However, with an intention to continue the legal profession as an advocate, he resigned from the post of Civil Judge, Junior District and Judicial Magistrate FC and resumed legal practice as an advocate in 2011. After resigning from the post of Civil Judge, JRDN, and after being relieved from judicial services, he resumed his practice as an advocate in the year 2011. And since then, he is practicing in Kolhapur in criminal, consumer, industrial, and labor court. In December 2016, Sir has been appointed as Assistant Government Pleader and Additional Public Prosecutor for Kolhapur District by Government of Maharashtra. And since then, he is also representing the state of Maharashtra as well as its various department posts. Department, Forest Department, Department of Health, etc., and other government incorporation and entities like Employees Provident Fund, Organization, BSNL, etc. Sir has been appointed as Special Public Prosecutor for Maharashtra for Control of Organized Crime Act cases for the MCOCA Court, Kolhapur. Without further delay, I would like to invite our keynote speaker for today's guest lecture, Advocate Amit Mahadeshwar sir, to enlighten us with his knowledge. Advocate Amit Mahadeshwar sir, please.
Namaste, am I audible?
Yes, sir.
I express my heartfelt thanks to all of you for granting me an opportunity to share whatever knowledge I have gained throughout all my practice in the field of law. The subject which was given to me or which is given to me is Protection of Children from Sexual Offences Act 2012. Friends, rather going into theoretical way, I would like to go in practical way. That is the manner in which this particular act is to be implemented in practice and the procedure with respect to this act. As all of you are well aware and all of you are studying that the law consists of mainly two lines: substantive law and procedural law. Procedural law and substantive law. In respect of substantive law, it can be said that substantive law defines the rights and liabilities of the litigating parties, whereas procedural law provides the procedure to implement the substantive law. Some laws are combining procedural laws as well as substantive laws, and this particular act, that is Protection of Children from Sexual Offences Act 2012, has been a law which consists of substantive provisions which define the offences, the punishment for offences, and the other provisions with respect to the procedure which has to be carried out by the police machinery during the course of the investigation, and the procedure for the trial of this particular case, the manner of recording of the evidence, and also constitution of the court as well as appointment of various authorities or various stakeholders in this particular context. Now, as all of you are aware that this particular act was enacted in the year 2012. The background of this particular act or the background behind legislation of this particular act is caused due to the various factors. The earlier scenario was to the effect that the offenses relating to the sexual offenses or sexual offenses were defined in IPC, especially under section 354, 350, 375, 376, 377, as well as 509. However, these offenses regarding outraging the modesty of women, rape, unnatural offenses, and attempt to commit such offenses were inadequate, and especially the inadequacy was faced due to the fact that these provisions were gender specific. That is to say, only except section 377, all the offenses, that is offense punishable under section 354, 375, were or could have been committed only against women or girl child, that can be said. But with respect to the offenses which have been committed against the boys or the or the boys did not have adequate provisions with respect to the punishment in IPC, and that could be that was highlighted by the Honorable Supreme Court in Sakshi, in the landmark judgment of Sakshi versus Union of India. Now, after the enactment of section POCSO Act in the year 2012, certain special courts have been designated as a special court for POCSO cases, and the trials are being conducted. Now, if we consider the whole scheme of this particular act, this act comprises of substantive provisions which define the offences under this act, and they are contained mainly in the chapter 2, 3, 4 and 5 of the act.
Sorry to interrupt, but let me know when to share the PPT given by you.
Can you see the PPT?
Yes, sir. Yes, sir.
I will share for you.
Pardon?
I will share for you.
Can the PPT be seen?
Oh, yes, sir.
Okay. So the first 5 chapters, or from chapter number 2 to 5, the offences are defined, and the liability or responsibility of reporting the offences is defined. In the chapters from chapter 6 onwards, there are provisions with respect to the recording of the statement of the child, that is the stage of the investigation. Then chapter 7 lays down the provisions with respect to the designation of special court or the constitution of the special courts, then the presumptions under this particular act, then appointment of special public prosecutors for conducting the cases under this act or cases registered under this act. Chapter 8 also defines the procedure and powers of the special court and recording of the evidence. And the chapter 9 is providing for miscellaneous provisions with respect to the guidelines for child to take assistance of the experts, etc. And certain exceptions or the acts which may not amount to offense. Now, with this particular context, if we consider the purpose of this particular act, it was an act to provide protection to all children from offenses of sexual assault, sexual harassment, and pornography, and provide protection to children from sexual offenses by adult abuser. Now, under this particular act, any child of any sex, that is gender neutral, whether it is girl or a boy, below 18 years of age is defined as a child. Now, in this particular context, the offenses under this particular act are similar to the definition of the rape in IPC. However, the distinction has been made because rape, which is gender specific, now this in this particular act, the definition of sexual assault and penetrative sexual assault and sexual harassment are given. Section 3 defines penetrative sexual assault. Then Section 5 provides the definition or the provisions of aggravated sexual assault. Section 7 defines or lays down what amounts to sexual assault, and Section 9 defines or provides for the provisions with respect to the aggravated sexual assault. Then Section 11 of this particular act lays down the provisions relating to sexual harassment of child, and Section 13 lays down what amounts to use of child for pornographic purpose. Now, as Section 3 defines the penetrative sexual assault, the definition itself suggested that any assault which is of penetrative nature or any sexual assault which is of penetrative nature, that would be covered in the penetrative sexual assault. That is penetration of any object in the private part of this particular any child, or to causing the particular child or the victim child to cause penetration into any person's private part. So this is what amounts to penetrative sexual assault, and the category of these particular offenses are subcategorized into two classifications. That is the penetrative sexual assault or sexual assault, and aggravated penetrative sexual assault and sexual assault. And it is defined on the basis of the person who commits such offense or the position or authority of this of the person who commits such offense. Now, under this act, offense is aggravated when it is committed by a person in position of a trust or authority such as police, army, security person, public servants, and family members. Now, this particular aspect, if we consider the reason behind this particular aspect as to why such attack or assault is called aggravated, because these particular persons hold the position of trust or authority, or in a way they can dominate the will of this particular child or the child which is subject of the sexual assault. Apart from the same, the assault which has been committed by the person in the management or staff of the educational, medical, religious institution, committed by a person in the management of staff or jail or remand home, protection home, observation home, or any other place of custody or care and protection. The very intention behind this particular provision for defining these offenses as aggravated only because all these persons as defined who can commit these offenses can hold the authority, can dominate the will of this particular person who is subject of such assault or such offense, and they are also in position to suppress such offenses, and only because of the same these particular offenses have been defined as aggravated or offense of aggravated form. Apart from the same, when a person who has been convicted of committing such offense either under the POCSO Act or any other law, and when the offense has been committed in the course of communal or sectorial violence and in the case of natural calamities also. Now, if we consider this aspect, the first one is offense committed by the person who has been previously convicted under this act and or any other law. Now, that amounts to similar offense which has been committed, that is sexual offense which has been committed under any other law or under this particular POCSO Act. And when offence has been committed in the course of communal or sectorial violence, am I audible? Hello?
Yes.
Yes, sir.
Now the next comes in sequence, that is the punishment which has been provided under this particular act. Different punishments have been provided for penetrative sexual assault, aggravated penetrative sexual assault, and aggravated sexual assault, as well as sexual harassment of child. Now, for penetrative sexual assault, the punishment which has been provided is minimum of 10 years and which may extend it up to life imprisonment. And if the penetrative sexual assault has been committed on the child below age of 16 years, then the punishment is in the enhanced form, that is minimum 20 years rigorous imprisonment, and which may extend to life, that is remainder of the period of the convict, that is up to his death, and also fine. And such fine has to be just and reasonable. More often we see that whenever any person is convicted, fine which has been imposed or generally which is imposed is not sufficient to rehabilitate that particular person or the victim, or to take care of his rehabilitation, or to take care of the expenses or the medical expenses which have been incurred for the treatment of this particular victim. And therefore it has been provided that the fine which is to be imposed has to be just and reasonable, and that is sufficient for rehabilitation and medical treatment of that particular victim. As far as aggravated penetrative sexual assault is concerned, the minimum punishment is 20 years rigorous imprisonment, and which may extend to imprisonment for life, that is remainder of the life, and fine. Now we may come across this particular scenario if we consider the punishments which have been provided in the IPC. Specific note to the effect that the life imprisonment means remainder of the life has not been, or it is not found in IPC. However, in POCSO, such specific provision has been given, because if we consider the other aspects of the criminal trial or the scenario subsequent to the trial, if we consider section 433 of the Code of Criminal Procedure, as well as article 72 and article 161 of the Constitution of India, then these particular provisions provide for the mechanism for pardoning of the punishment, pardoning of the accused who has been convicted. And in such case, generally what happens, when the person is convicted for life, after a period of 14 years, the government may release him, considering his behavior when he has been in imprisonment and considering the nature of the offense, because it can be considered, or it has been laid down time and again, that the object of the law is to cure the person, and that is why after 14 years of jail period, or after undergoing 14 years of period of imprisonment, generally the government considers to release the convicted who has been convicted of life imprisonment. And therefore, in order to curb the same, specific wordings have been inserted in this particular punishment, that life imprisonment means remainder of the life, and that is because this particular penetrative sexual assault which have been committed against the victim below 16 years and sexual assault which is of aggravated nature. Now, with respect to sexual assault, the punishment which has been provided is 3 to 5 years and fine. And in case of aggravated sexual assault, the punishment which has been provided is from minimum 5 years to 7 years and fine. Then there is provision for sexual harassment of the child. Punishment which has been provided for sexual harassment of child, which is up to 3 years. Then the punishment for use of the child for pornographic purposes is minimum 5 years, and in case of subsequent offences, it is 7 years and fine. And if along with the pornographic act, offences are also committed under section 3, that is, as we have discussed, that is penetrative sexual assault, aggravated penetrative sexual assault, then sexual assault and aggravated sexual assault, then the punishment are also provided. Then there is also a provision for storing, possessing or pornographic material involving a child for sharing and transmitting purpose, and that is punishable with fine which shall not be less than 5,000 and which can be upward of 5,000, and in case of subsequent punishment, subsequent conviction, with fine which shall be minimum 10,000 and upwards. Then the punishment is also as we have already discussed, which is up to 3 years for storing and possession for commercial purpose. It is minimum 3 years to 5 years, and for subsequent conviction, minimum 5 years to 7 years. Now, one of the most important aspect of this particular act is with respect to the definition of abatement and also attempt to commit an offense. As we can see in the IPC, the definition of abatement are standing on some different footings. But with respect to the offenses relating to abatement under this act, the definition is on different footing. As far as abatement with respect to this act is concerned, that is instigation by any person to do instigation, whoever instigates any person to do the offense, do that offense, that is offense punishable under this particular act. Secondly, who engages with one or more or other persons in any conspiracy for doing of that offense, and if an act or illegal omission takes place in pursuance of that conspiracy and in order to doing of that act, or intentional aid by any act or illegal omission or doing of that offense. These particular provisions are important in view of the fact that this act also punishes the act of non-reporting of the offense by certain persons. This is very important in the scenario that more often we see that whenever any offense has been committed in any institution or any particular establishment, we may say, the first attempt of the stakeholders of that establishment is to try to conceal that particular offense or to get the matter compromised. And in order to curb this particular aspect, these provisions are very much important. We may discuss in the course of this particular discussion. The punishment for abatement as provided under this act is equivalent to the punishment provided for the act which has been abated. And section 18 of this particular act also provides punishment for attempt to commit an offense under this particular act. And when an act or the offense has been attempted to be committed, the punishment which has been provided under this act is of half of the punishment provided for that particular offense which has been attempted to be committed. Now, section 19 of this particular act provides the mechanism for reporting of these particular cases or reporting of the offense. It has slight different parameters than FIR under section 154 of the CRPC. This particular reporting of the act of the offense can be reported only even if there is apprehension that an offense under this act is likely to be committed, or whenever any person has knowledge that an offense has been committed. So in both contexts, this particular FIR can be given. As far as FIR under section 154 is concerned of the CRPC, which is we may say for the purpose of convenience, regular FIR under the CRPC, which is with respect to the offense of cognizable nature which has been committed. That is to say that FIR is given after the offense has been committed. But with respect to these particular provisions, whenever there is apprehension that an act is likely to be committed, such FIR can be lodged. And the FIR can be lodged to the special juvenile police unit as well as with the local police. The other aspect with respect to this particular reporting is concerned with the police, that this particular FIR has to be recorded in the knowledge or as stated by the child if it is given by the child, and if that particular child is not able to express the same in the proper language, then the interpreter or translator, the help of the interpreter as well as the translator can be availed of, who has certain qualifications and experience with respect to the language which is understood by the child. And when the SJPU, that is Special Juvenile Police Unit or local police, is satisfied that this particular child against whom the offense has been committed is in need of care and protection, then after recording for such reason, they are bound to make immediate arrangement to give him such care and protection, including admitting the child into shelter home or nearest hospital within 24 hours of the report. Now, it is mandatory upon the concerned police station to report the matter to the Child Welfare Committee and the special court within 24 hours. That is a provision which is analogous with the reporting of the cognizable offense to the CJM. Whenever any FIR for cognizable offense has been recorded, that has to be sent to the concerned court or the concerned magistrate that is similar to the same. Now, the most important provision with respect to reporting of the offense under this act, as we discussed, that whenever there is an apprehension that such offense is likely to be committed, even in that case, such report can be lodged. And for that purpose, an exception has been given that suppose in case such offense, there one person is apprehending that such offense against the child is likely to be committed, then he may report, and it may be found that the offense was not being committed. Then, in case the information may be treated to be not correct, and in that case, such person shall not incur any liability, whether civil or criminal, for giving information in good faith for the purpose of subsection 1. Suppose a scenario whenever a person, as we discussed, has lodged an FIR that such offense is likely to have been committed or is likely to be committed, and he files the FIR under this particular provision to the nearest police station or the special juvenile police unit. That will certainly amount to, if the in other cases, it may amount to his defamation or defamation of the concerned person. However, whenever such information has been given in good faith, even when the offense has not been committed, then the such liability is not incurred, and that is why this particular provision is made in order to facilitate the reporting of these particular offenses, or whenever there is apprehension of commission of such offense. Now, obligation, the next provision is with respect to the obligation of media, studio and photographic facilities, or any lodge, hotel or hospital, by whatever name called, on coming across any material or object which is sexually exploitative of child, including pornographic, sexually related and making obscene representation of child or children through the use of any medium, shall provide such information to special juvenile police unit or the local police as the case may be. Because this particular kind of persons, say a person or personnel of a hotel or a lodge where boarding facilities have been provided, or the hospital or a club or studio or photographic facilities. Now, all these places can be used for the sexual exploitation of the children, as well as for capturing pornographic activities or for capturing pornographic acts. So it is a duty cast upon this particular personnel, whoever is working in this particular establishment is mandated to provide such information to the special juvenile police unit or the local police, and such failure to report such offense is provided with punishment. The second aspect in this particular scenario is with respect to any person being in charge of a company or the institution in respect of such establishment, if he fails to report the commission of an offense as provided under section 19, that is, his duty is to report the offense. In that case, such person holding the charge of that particular establishment is liable for punishment up to 1 year and with fine. Section 22 and section 23 provide for the punishment for false complaint and false information. Punishment for false information. Now, as we discussed in the section 19, there is provision for exception whenever an offense is reported in good faith and such information is not found to be correct, then he is not incurring any liability or is not incurring any liability for the offense. However, when a person makes false complaint and provides false information against any person of having committed offense punishable under section 3, 5, 7 and 9 with intention to humiliate, extort and threaten to defame him shall be punished with imprisonment for term which may extend to 6 months or with fine or with both. And such such offense, whenever there is attempt for extortion as well as when there is threat, then that will also amount to extortion under IPC as well. But in addition to the same, this particular person, if only for the purpose of humiliation, for the purpose of extortion and for the purpose of defamation, if such information has been lodged with the concerned police station, then such false reporting would incur liability under section 22. Now, as far as child reporting such false information is concerned, then that particular child has been provided with immunity under this particular act, because a child is considered to not knowing the consequences of his act, and therefore a child, if reports any false information, then he is not liable for punishment. However, whenever false information has been given against a child, then in that case punishment for victimizing that particular child is up to 1 year and fine and with both. If we see this particular scenario, then it can be seen that for the purpose of or the in respect of the aggravated form of these offenses, extended punishment has been provided. And the most important factor or the most important aspect of this particular act is with respect to the media or the procedure of for media. We often see in our nation that for gaining publicity or for gaining the TRP, what we call the TRP in cases of media, very aggressive reporting has been made by the so-called journalists, which may tarnish the image of any person who is yet to face the trial, or in regular context it has been called as media trial. And in the course of media trial, the names of the persons who are involved in that particular case, be it victim, be it accused, are disclosed, and such information is being spread or often being spread from the residents as well as from the educational institute or the employer of that particular victim as well as the accused. Such information is being spread by the media, and ultimately it affects both sides. If the victim is subjected to such treatment or the identity of the victim is disclosed in such manner, then in our society sexual offenses are still considered as a taboo upon the character of that particular person. We have to accept the same, and therefore it has been provided in section 23 that the name, address, photograph, family details, school, neighborhood or any other particulars which may lead to the disclosure of the identity of the child shall not be disclosed in any manner whatsoever by the media. And if such prohibited act is contravened, then the punishment which has been provided is minimum 6 months, which may extend to 1 year. The court, however, is having discretion to permit the media to disclose such information if it is in the interest of child. Say or consider a scenario where a child has been abducted and the whereabouts of that particular child are to be found out. Fine. In such scenario, not necessarily in that particular scenario, but in such scenario, whenever such disclosure would be in the interest of the child, then such disclosure is permitted. Now, with this, the offences and the procedure for reporting the offences is concluded in the first 5 chapters of this particular act. Now, the next comes is the procedural aspect, and the procedural aspect in this particular act are provided in during the stage of the investigation as well as during the course of the trial in respect of the offences in this act. Now, as far as possible, it has been tried by the legislature to simplify the procedure for child. We may often see that a child or the child who is a victim or who is a witness to that particular offense, by natural nature of the children, there may be hesitation, there may be fear, there may be element of apprehension with respect to the authorities and especially the police. Then there is possibility that such child may not disclose the facts known to him, and therefore for recording the statement of the child, not necessarily the victim but the child who is also witness, some simplified procedure are provided. As far as the code of criminal procedure is concerned, for the recording of the statement of the women, there is provision that the statement of the women during the course of the investigation has to be recorded at her place of residence or any other place as per her choice. But she cannot be compelled to come to the police station to visit the investigation officer for recording of her statement. But in this particular scenario, as there is similar provision in CRPC for the women witness, similar provision is given in this particular act, that is the statement of the child has to be recorded at his residence or any place of his child's choice. Now, one more caveat is imposed upon this particular procedure, that the officer who records the statement of the child should not be below rank of sub-inspector. Considering the aspect that this particular act has provided very stringent provisions and stringent punishment, and considering the nature of the act which provides the mechanism for protecting the interest of the child as well as his well-being, this particular aspect has been added, that a person or the officer having the responsibility should be deputed for the purpose of recording statement of the child, and such police officer should be a women police officer and not male police officer. The next important provision is that in order to pacify that particular child or to create child-friendly atmosphere, the police officer should not be in uniform. Because what happens whenever a child sees a police officer, they may not disclose, as we discussed, or they may fear the police officers. That is why it has been provided that the police officer shall not wear uniform when he is recording the statement of the child. During the course of the investigation officer is bound to ensure that the child does not come in contact with the accused and is not in any way influenced by the accused. Because sometimes what happens, as we have seen earlier while discussing this particular scenario, that whenever a child is resident of a hostel or when an offense has been committed by the family member, then the child may come in the contact with the offender, and that may lead to brushing aside the statement, or that may coerce or dissuade that particular child from not disclosing or from disclosing the facts which are known to that particular child before the investigation officer. And therefore provision has been made that such child should not come in the contact with the accused. And the further provision is with respect to the child, that that child should not be detained in police station for any purpose in the night, and in that case the child is required to be provided with the proper provision either to his parents home or to the shelter home, whatever is necessary in that particular context. Then for recording of the statement, as we have discussed earlier, assistant of translator, interpreter and educator may have to be taken, and the statement of the child has to be videographed by electronic means. Now section 25 of this particular act provides for the recording of statement of a child by magistrate. Under section 164 of the CRPC, statement of the persons can be recorded by the magistrate during the course of the investigation. It may be confessional statement, it may be a statement by a witness. And the magistrate is empowered to record such statement by following the due procedure under section 164 of the CRPC. As per section 164 of the CRPC, whenever the recording of the statement is to be videographed, or whenever statement of the witnesses is to be videographed, then the advocate for the accused can be permitted to remain present at that particular time. However, whenever a statement under section 164 of the CRPC is to be recorded by the magistrate under this act, then such advocate of the accused is not entitled to remain present at the time of the recording of the statement. Whenever statement under this particular act under section 164 has been recorded by the magistrate, he has to give the copy of that particular statement which has been recorded by him to the parents or the representative of the child or to the child itself. Now, these particular statements have to be recorded in the language which has been spoken by the child, or in the words specifically we can say in the words spoken by the child. Normally these particular provisions are there because as far as possible it has been seen by the legislature that this particular aspect of the investigation as well as trial should be of simplified nature. Therefore, considering the nature of the offense and considering the punishment, a balance has to be struck with respect to the rights of the child as well as fair trial as envisaged under the constitution as well as the other acts of the which are prevailing in the India. Now, sometimes what happens, a person may addressing a particular act in a particular manner, and the other person may be understanding or maybe addressing that particular act in particular manner, and therefore the words of the child are important, and therefore it has been provided that the statement as spoken by the child in the presence of the parents has to be taken. Means the word should be, normally what happens, it can be seen or it is more often seen that when recording, while the recording of the statement of any other witness or the concerned accused, when the confession is recorded, sometimes what happens, judicial officer may take the contents or let the witness speak and may record the same in his own language so as to suit the as per the record. But for curbing this particular scenario, it has been provided that actual words should be taken on record, and the other provisions are relating to the translator, etc. Now, the next aspect is with respect to the medical examination of the child. The medical examination has to be conducted as per section 164A of the CRPC. If the medical examination of the child is to be conducted upon a girl child or female child, then it has to be conducted by the lady doctor, and such medical examination has to be conducted in the presence of the parents, and when the parents are not present, by the person who has been designated by the concerned hospital. Now, the medical examination of person provides the evidence with respect to the offense, and that is why the medical examination of the victims of sexual assault has to be conducted. Apart from the same, the medical examination of the perpetrator or person accused of having committed sexual offenses has to be conducted, because that is most important aspect of the trial with respect to these offenses, because the accused may raise number of defenses with respect to his potency, with respect to the alibi, with respect to any other aspect, and for assessing those particular aspects, the medical examination is very much important. Now, for the trial of these offences, it has been provided that a court of session in each district is to be designated as a special court for speedy trial, and appointment of special prosecutor only for purpose of conducting these particular trials, and these provisions are in section 28 as well as section 32 of this particular act. The most important factor of this particular setup, or the most important reason for establishing this particular setup, is only to ensure that the trials are conducted speedily. More often we see that in general terms or in general practice, whenever a charge sheet is filed or report under section 173, as laid down in the CRPC, whenever a charge sheet is filed and when the court takes cognizance of the same and the matters are committed to the court of the session, if the matter is triable by the court of session, then it may take from 2 to 5 years at least for complete trial of this particular case. And due to the lapse of time, what happens that the concerned witness may forget or the facts are not been able to be disclosed before the concerned court, and the benefit of the same can be obtained by the concerned accused or concerned person. And that is why it is necessary to ensure that the trial is conducted as expediently as possible. Then the second aspect with respect to the trial is that the child should not suffer from the trauma of that particular sexual assault throughout the years till the trial is conducted, or throughout the years till his statement or till his evidence is recorded. And therefore it has to be ensured that there is special court, because normally what happens, we have often seen that, and it is bound to happen, because normally in our country the court are burdened with heavy number of cases, and therefore for reaching the conclusion of trial it takes much time. And therefore if these particular offences are to be tried by the regular court, then there are bound to be a delay, considering the fact that there are other cases also. And therefore the constitution of the special courts is provided, and the most important aspect in this regard is that a senior judge having the designation of court of session can be appointed as a special court, and no judge below the rank of session judge. That ensures the sufficient maturity to with respect to these particular trials. And as far as public prosecutor is concerned, there is provision for special public prosecutor on the same analogy, that if a regular public prosecutor is assigned with the duty to conduct the cases under the POCSO Act, then owing to his other cases there may be delay in conducting these particular trials, and therefore there is provision for appointment of public prosecutor. Then with respect to the procedure and powers of the special courts, certain guidelines or certain mandatory provisions have been provided for the special procedure and powers of the special court with respect to the trial. Now, if we consider the scenario in the court, whenever any witness is being examined, be it examination in chief or be it cross examination, then the most difficult task in the trial, in my opinion, is to depose before the court. Because what happens, whoever may be a person, whatever may be his background, but whenever it comes to enter in a witness box, any person of any standing or any mentality has certain nervousness to depose, and therefore this particular aspect has been considered with respect to the child. Suppose there is a victim of sexual assault, the child who is victim of sexual assault, if certain special procedures are not laid down, he may not be able to depose properly. And therefore regularly what happens, as you have seen during the course of court visit as well as chamber visits, you must have seen that in the cross examination of a regular witness who is not a child, or in the course of regular trial, after the examination in chief is over, the cross examination is conducted by the defense lawyer or the advocate for the accused, and the questions are directly put up to the witness. There is no intermediary, or the public prosecutor who conducts the examination in chief also addresses the witness directly. In the cross examination, generally what happens, there are chances that the witness may be bullied or attempt may be made to intimidate that particular witness or to cause pressure on that particular witness of psychological nature. And therefore, such child witness should not face such scenario, has to be ensured. And therefore, provisions have been laid down that in the course of trial under this act, the prosecutor as well as the defense lawyer is bound to convey the questions to the court, and the court in turn or the special judge shall ask the question to the child, so that the child is relieved of a stress or mental stress out of this particular examination and cross examination. Now the second aspect with respect to this particular recording of the evidence is that generally what happens whenever there is a trial of any case, and suppose there are witnesses from a same family with respect to the incident of the offense, then if the adult witness is there, then no person who is witness to that particular incident is permitted to remain in the court hall, because that may lead to the scenario that that particular witness who hears or who sees the cross examination is getting the defense line or is able to assess what examination, or he is able to anticipate what questions are to be asked or what questions will be asked in the course of the cross examination to him when he is to be examined. And in that cases, such persons are not permitted to remain present when the evidence is being recorded. However, exception to that particular scenario has been given in this particular procedure, that whenever a child is being examined, his parents or his guardian or his friend, even if they are witness to this particular incident, can remain present or are permitted to remain present when the evidence is being recorded. It is also provided that the child shall not be called repeatedly to testify in the court, and the act provides that the statement or the evidence of the child should necessarily or as far as possible be recorded within 1 month from taking cognizance of the offense. Further, it is necessary, as we have seen in section 23, the media is not permitted to disclose the identity. Similarly, in the course of the trial, the identity of the child should not be disclosed, and even in the judgment, the name of the child should not be mentioned in the judgment. Any assumptive name should be given, that is the child X, child A, child B, etc. Now, the aggressive questioning is not permitted, and character assassination of the child is not permitted during the course of the cross examination, because that is very much important, because that aggressive questioning, as we have discussed earlier, there are attempts from the side of the defense to put psychological pressure upon the witness, and there are chances that witness being intimidated, and therefore, as we have seen, the provision is with respect to the questions have to be put through the judge itself or the special judge itself. The next important aspect in this particular context is trial is to be conducted in camera. Now, when we were in college, we used to understand in camera is to the effect that cameras are to be placed to record that particular trial. But in camera amounts to the trial which is conducted in the four boundaries or the four walls of the court hall, and when any other person who is not concerned with the case is not permitted to remain present in the court hall. Otherwise, as per the Code of Criminal Procedure and as per our prevailing laws, the court is to be open for all the public, except the scenario of COVID-19, when only restricted access to the court was permitted to even advocates. But in case of trial under this act, the trial is to be conducted in camera. That is to say that no person other than the person who are concerned with the case are permitted to remain present inside the court hall. And the most important aspect in this regard is when the evidence of the child is being recorded, then it has to be ensured that the child shall not be able to see the accused and the accused shall not be able to see the child. And therefore, whenever there is trial under this act, a partition is placed in between the witness box and the place designated for sitting of the accused at the time of the trial. And therefore, it is ensured that, and it has to be ensured that the child should not be able to see the accused, because what happens, even by the gesture of the eyes, the child can be prevented or dissuaded from disclosing the facts before the court. And therefore, it has to be ensured that child should not be able to see the accused, and partition is to be imposed, put up between the witness box and the child. Now, even during the course of the trial, the special court may take the assistance of interpreter, translator, and special educator. That is for ensuring that the proper words which have been deposed by the child are taken on record. And as we have discussed earlier, the evidence of the child has to be recorded within 30 days from taking cognizance of the offense. Now, a deadline has been imposed in the trial of this particular case, particular offenses, that the trial has to be completed within a period of 1 year, and if the trial could not be completed within that particular period, then it has to be recorded in writing by the concerned judge as to why the trial is not completed within that particular period, owing to any reasons. Suppose there is reason that the COVID situation was there, and for more than 6 months the court were not functioning. Such scenario is there. Then there is scenario whenever there is scientific evidence. When there is scenario of scientific evidence, say there are samples which are being sent for DNA analysis, and they are not obtained within the time or within the time frame prescribed under this particular act for the trial, then in that case, it has to be ensured that all the evidence or all the material evidence has come on the record, and for that purpose, such extension of time can be granted or can be taken, but that has to be recorded. Now, the other provisions are with respect to the implementation of the Act and uh, liability or the onus on the central as well as state government to ensure that the provisions of this particular Act are spread into a general public or public awareness is created with respect to the provisions of this Act. And there is also liability upon the central as well as the central state government to ensure that the officers who are concerned in this Act or who are concerned for enforcement of this particular Act are adequately trained. Then, be it the special judge, the special public prosecutor, or any other person, the investigation officer may be there. And therefore, these provisions are there. In this particular context, one important provision is with respect to the entitlement of the child to take the assistance of legal practitioner of their choice, or parents as well as the child are given assistance of parents, legal practitioner of their choice when conducting the trial under this Act, in view of the subject to the provisions of course, Section 301 of the Code of Criminal Procedure, which provides that person or the legal practitioner who is appointed by the victim or the de facto complainant is entitled to address the court by way of written argument and is entitled to assist the prosecution under the guidance of the public prosecutor. Now, the most important aspect with respect to the procedure in this Act are presumptions under the with respect to certain offences. As we also, or as you all must be aware about the Indian Evidence Act, in Section 4, there are provisions with respect to the presumptions, when court may presume, when court shall presume, or what amounts to may presume and what amounts to shall presume. Then, as per Section 114 of the Indian Evidence Act, there are certain provisions with respect to the scenario when the court may consider the certain facts, existence of certain facts. So these are the provisions with respect to the presumptions, and there are multiple presumptions under the various acts. But normal rule of the criminal trial is to the effect that the accused is to be presumed to be guilty, innocent until proved guilty, and that is having source from the Constitution of India. In this particular trial, there is an exception. Section 29 of this particular Act provides that where a person is prosecuted for committing or abetting or attempting to commit any offense under Section 3, 5, 7 and 9, that is penetrative sexual assault, aggravated form of sexual assault as well as penetrative sexual assault, and and aggravated penetrative sexual assault and aggravated sexual assault. Then the special court shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless contrary is proved. So this particular rebuttable presumption can be seen under this Act. this implies that the accused has to prove that he is not guilty. He has to rebut the presumption by proving contrary. Now, in a normal rule or in a normal trial, the accused is able to prove or he can remain silent. It can be seen that from number of times the Honorable Supreme Court as well as Honorable High Court have laid down that the accused has right to keep mum or to remain silent. The prosecution is burdened in normal trial to prove the offense of the accused beyond reasonable doubt. But in this case or in the cases under this act, this rule is reversed and the accused is bound to prove that he is not guilty. Now, section 30 provides the presumption for culpable mental state. The other aspect with respect to the presumption of as to certain offenses. In most of the acts, whenever there is presumption is based, the presumption is depend upon proof of certain facts in other scenario. But in this act, whenever prosecution is there, that is to say, whenever charge sheet is filed and court takes the cognizance of the offense, then the burden of not proving guilty is upon the accused. Then there is presumption under section 30 of the culpable mental state, and that lays down that whenever under this act any act requires culpable mental state, that is mens rea, as we have already learned or we have already read during the course of our academic years, that for any act to amount an offense, the mens rea must be there. That is, culpable mind or the guilty mind has to be there. But in this context, whenever there is any act or any offense under this act which requires culpable mind on the part of the accused, in prosecution under this act, the court shall presume that accused has that particular mens rea or such mental state. Of course, the accused is entitled to prove that he had no such mental state with respect to the act which has been charged. And for the purpose of proof, the regular context of the Indian Evidence Act is given in this particular section, that a fact is said to be proved only when the special court believes it to exist beyond reasonable doubt and not more merely when the existence is established by preponderance of probability. So again, the heavy burden of not proving the mental state is upon the accused. So in this context, this particular act is having different parameters with respect to the presumptions and with respect to the liability of the prosecution as well as the accused in the trial. As far as trial under this act is concerned, the procedure as applicable as per the Code of Criminal Procedure is applicable in this context also. And the trial is to be conducted as per the trial of warrant case before the Sessions Court, instituted on police report or otherwise than on police report. I hope that I am able to share whatever in limited words or whatever in utmost precise words, whatever I could have shared with you.
Yes, sir. Thank you so much. Now, if someone has any questions to ask, they may unmute themselves and ask, or drop down their questions in the chat box. काही questions आहेत का? So there is a question. What happens if the accused is also a juvenile?
If the accused is also juvenile, then his age has to be determined. Then, after ensuring that when the accused is juvenile, then he has to be treated and he has to be tried as per the Juvenile Justice Act.
So one more question.
Yes.
So if a child is not aware that when the offense was committed that it was a sexual offense, and later after growing up, if that realization comes, can still a case be filed?
Yes, there is no time limit for reporting the offense. Even if we consider the Code of Criminal Procedure and especially the limitations laid down in the Code of Criminal Procedure, whenever there is offense and if the concerned informant is able to satisfy the court or the concerned complainant is able to satisfy the court that due to the reasons beyond his control or due to sufficient reasons he was prevented from reporting that particular offense, then even after the period of limitation is over, still then the cognizance can be taken. And if we consider the provisions of CRPC, then the time limit or the limitation for reporting the offense is with respect to the offense which have been punishable up to 3 years, and for the rest of the offenses which are punishable with imprisonment for more than 3 years, there is no upper time limit or no ceiling limit for the limitation has been given in the CRPC. So if we consider the offense under this act, as we have discussed earlier, the punishments which have been provided for penetrative assault, sexual assault, or sexual harassment are 3 years and upwards, and therefore the hindrance of limitation would not be attracted in this particular scenario. Further, there cannot be any adverse inference for not reporting the offense when the offense was committed or when the offense has been committed few years back. The offense is an offense and the offender has to be punished, and therefore there is no limitation.
Right. Thank you, sir.
So there is another question.
Yes.
Can unknown person text on social media? Is that under IPC 354 punishable?
Pardon?
Can unknown person text on social media, and then is that under IPC 354 punishable?
And for social media posts,
Yeah, the text on the social media.
section 67B of the Information Technology Act is there. Okay. Then section 354A, the subsequent amendments with respect to if that act amounts to an offense under that particular act, even if it is committed or posted on social media, if it is against the Indian citizen, then he can still be prosecuted for the offense. because as far as computer source is concerned, that has to be concern universal and it can be considered over here also. And suppose that person is unknown, that won't make any difference. The crime has to be reported, and during the course of the investigation, it can be gathered whether he is or whereabouts of that particular accused.
Okay, sir. And there's one question that when you say that the act is gender neutral, is it only gender neutral as to the victim, or does the law assumes that the offended or the accused is a man precisely, as Section 3 says a person is said to commit a sexual assault if he penetrates?
Any person, then that will show that any woman who has committed such offense, still she can be punished. So the act is gender neutral with respect to the child as well as, or the victim as well as the perpetrator.
Thank you, sir. And another question, is
One
more
more aspect in this regard, as far as gender neutrality of the offender is concerned, if we consider the provisions in the IPC with respect to section 377, 360, 76, etc., specific word has been given, whoever, any man, reference to man is there. So as far as this act is concerned, it is gender neutral with respect to the child as well as perpetrator or the offender.
Thank you, sir. So also is more storage of pornographic content of a child punishable under this act?
Yes. Pardon?
Okay. So is more storage of pornographic content of a child punishable under this act?
If it is stored with the purpose of transmitting the same or for taking pleasure or sexual pleasure out of that particular pornographic content, then it is an offense. However, if the pornographic content is stored for the purpose of reporting the offense, then that storage will not be punishable under this act.
Okay, sir. Thank you. Are there any more questions? Uh, so now I request everyone to kindly switch on their cameras so that we can take a group photo as the memory of this session. Is the picture taken? Asher?
Yes.
Okay. Now, on behalf of NSS Unit of Government Law College, Mumbai, it's my privilege to propose a vote of thanks on this occasion. My heart fills with gratitude and respect for our distinguished guest speaker, Advocate Amit Mahadeshwar sir, for not only sparing his valuable time for us to grace this occasion, but also for enlightening us with their commendable talk on the subject. Thank you for clearing our concepts and enhancing our understanding pertaining to the POSCO Act. We really owe you a lot. I'll also like to thank our beloved principal, Dr. Asmita Vaidya ma'am, and program officer of NSS unit, Ms. Kritika Tembhonikar ma'am, for constantly supporting and encouraging us towards our NSS motto, not me, but you. I'll also like to thank all teaching and non-teaching staff of Government Law College, and last but not the least, all the attendees for making this lecture a grand success. I once again thank everyone present here and back of the wheel who have helped us in successful conduction of this event. Thank you, everyone. I'll also like to mention that everyone present here is kindly requested to fill the feedback form given in the chat box. With this, I'd like to conclude today's session on the Protection of Children from Sexual Offences Act. Thank you, everyone. Thank you so much, sir.
Thank you.